Okay, so welcome everybody. We are here today to talk about confidentiality, and now that you can hear me, we are going to give this a go one more time. Thanks for hanging with us, and really sorry about that. So today, Jake and I are here to talk about confidentiality. What I had said before was just that you can send us any questions that you have our way throughout the webinar. There will be a couple different points where I'll ask specific questions, and we'll do some scenarios and things like that. So you can use the chat box for that. But throughout, feel free to send questions our way. Doing it in the chat box is the best. I know there's some different features like raising hands and Q&A, but unless I direct you to that, I think it would be best to just put it in the chat if you can. Okay, so just a quick overview of the agenda for today. We'll go over some logistics and orient ourselves to the webinar, and then we'll get into some of the basics of confidentiality and privilege, where those things are when it comes to the RCWs in our state, exceptions to confidentiality and privilege and what that means for your organization and how to respond to those. And then we'll talk about some different strategies, both internally and externally, so amongst staff, and then when you're working with different community partners, things to keep in mind when it comes to confidentiality and privilege. Then we're also going to touch on some federal updates that have happened when it comes to confidentiality and some required data breach policies that are now in place, and just talk about breaches of confidentiality more broadly. And I also just want to share some resources because there is a lot of good stuff out there when it comes to confidentiality. There's a lot of older tools that are still very relevant. This is something that has been a part of our movement and like a cornerstone of our movement. And so there's good work from the past, and then there's good stuff coming out, especially as confidentiality overlaps with technology and different things like that. So just wanting to make sure everybody has the resources that they need when it comes to this. Okay, so to get us started today, I would be really interested to know, we've had a lot of interest in this webinar. Confidentiality is something that's been coming up a lot when it comes to training and technical assistance. I would love to hear in the chat what your most burning confidentiality question is, or what issues you've been facing when it comes to confidentiality in your community. Like what's on your mind when it comes to confidentiality. So if you could take to the chat and share that with us, this is going to be really helpful to guide what we're talking about today. And then also, this can be the beginning of a conversation about confidentiality, and would love to know what other resources and tools folks need.
So far I'm seeing questions about how to interact with survivors or talking about survivors on email or text. Some questions around mandatory reporting. How do we handle confidentiality in a small town or a small community? And a lot of stuff about responding to requests from other systems or community partners for information.
Yeah, so working with clients in public spaces. I have seen a lot of questions about emailing and texting specifically.
Thanks, everybody.
Okay, so just wanted to start with some framing. I like to think of confidentiality as a part of the advocacy toolkit. It is something that we have available to us to use in our work with survivors, and it is something that we have to offer to them. So, it's not just something that we have to do or something that we have to comply with as advocates, but it's actually a tool that we can use for different reasons in our advocacy, and it is dynamic in that way. It's not, just a form that people have to fill out, or just, saying we can neither confirm nor deny. It can actually do a lot of things that can be really helpful to survivors. So just some different aspects of that that I wanted to highlight are that, confidentiality is a key part of self-determination. That is, being able to have those conversations with the survivor about who they do and don't want to share things with, what they feel comfortable with folks knowing, and not. It's a way to build trust through those conversations, and for them to know that, advocates not only are not going to share things with other people, there are actually legal protections that make that true. And so being able to talk to survivors that you're working with about confidentiality, really puts the decision in their hands about who they want to share things with. It also is a unique feature of community-based advocacy services, because a lot of systems-based advocates, don't have the same protections, or, some things might be confidential and others might not. But, for purely community-based programs, confidentiality is something that, you're not having to share information with anyone else, as a part of getting services. And so that's really great thing for folks to know, especially communities that might have, historically, fraught or difficult relationships with systems. You're able to, talk through that and let them know what community-based advocacy looks like, and, what confidentiality really means. I did want to share, I'm going to share some more resources at the end, but as a resource, and also because I really just feel like this image touches on what I was trying to get at when it comes to, why confidentiality is, it's not just a thing we do, but it's like part of our relationships with survivors, is because it does, just really highlight self-determination, their survivor getting to decide, with whom and what they want to share information about their experiences of domestic violence with. And so the Confidentiality Institute, does some really great training and technical assistance, and has some different resources around, parsing out privacy, confidentiality, and privilege. And so I would highly recommend checking them out, as a resource when it comes to confidentiality. All right, and then just to highlight why it matters, which is, what I've been talking about here. Um, you know, we we hold a lot of information about survivors that we're working with, and they need to know that they can trust us with that information, and that not only are we not going to share it, but that we actually can't, unless there are very specific, circumstances in which they tell us that we can. It's important in the community because we are showing what our role as domestic violence advocates looks like. What does that mean? It can help, other community programs understand, oh, when I refer somebody to this program, this is what they're going to get. And we can uphold, our ethical role in that, other service providers aren't necessarily bound by the same, guidelines around confidentiality. So we do need to demonstrate what that means, and be able to, have that reputation of strong confidentiality in the community. And then, it is, at the end of the day, and what we're about to go look into, it is required by state and federal law. And so, we are complying with those laws that were really made to, um, outline what confidentiality means, and then what, we need to do to get there. And, survivors can know that they'll have that to lean on, and that's something that agencies are leaning on, when, requests for information do come in.
So all the things that we're talking about today, especially the state and federal laws, are specific to community-based domestic violence advocacy programs. So that the rules might be different if you're in a different kind of agency, especially if you work for an agency, if you work for prosecutor's office or law enforcement or any other kind of agency. If you work for a mental health program, you might have other kinds of confidentiality protections and restrictions that are different, or might even be more stringent, or you might not have some of the same confidentiality, um, rules if you work for a systems-based program. So it's just to know what we're talking about is specific to those programs. And I think it's really just super important for us to be really clear about what makes, like Heather said, what makes those programs unique, and to communicate that to people. It's part of what all those laws are. We've had over the years a lot of influence in writing those laws and those rules and regulations, and doing that from a place of what is going to be the best protections for survivors and their kids. So we want to really uphold those and be and sort of, like Heather said, be public about that so that other folks know what to expect from us and what survivors can expect from us.
So going into some of the basic pieces around confidentiality and privilege and where those show up for us in Washington State. These are the RCWs that guide confidentiality and privilege when it comes to domestic violence advocacy here. I did make a handout with all the relevant RCWs when it comes to confidentiality and privilege, and I was hoping to be able to share that in this webinar, but I am going to share that with everyone who is on the webinar here afterwards, just so that you can have that on hand to reference, or maybe to share with new advocates if they want to take a look at how this is all written out in the law. But so when it comes to the confidentiality piece, it is written into the law that DV programs shall not disclose information about a recipient of shelter, advocacy, or counseling services without the authorization of the recipient. On the other hand, privilege refers to conversations that have happened between the advocate and the survivor, and more often than not is talking about, perhaps an advocate being subpoenaed or something like that when it comes to sharing that information with, other folks, the court, things like that. Your communication with each other is privileged, and that it cannot be examined or shared with others. And then confidentiality is often, that's referring to records, documentation, things like that.
And applies to verbal communication as well. But the privilege is just a little bit extra protection that's similar to what, if you think about attorney-client privilege, it's very similar in the law what that means. If you go to a lawyer and talk to them about something, they can't turn around and share that information with somebody else, and they can't be required by a court to talk about that. Same thing with an advocate. So there are some specific guidelines and some specific restrictions on that. So if that's something you're concerned about coming up, it would be good to dive into that specifically within the law. But basically what that means is if you're talking with somebody as an advocate, you can't then be required to share that information with the court, even if you are subpoenaed. Quick jargon check here on the RCWs and the WACs and all that stuff. So just for anybody who this is not familiar to, the RCW refers to the Revised Code of Washington, and all those numbers. So that basically that's state law. When we have some legislation in the state legislature and we pass a new law, it gets coded into the Revised Code of Washington, and it gets one of these numbers, RCW blah, 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 blah. If you literally just Google RCW 770.123.076, it will come up and you'll be able to read that whole law. And then in a minute, Heather's going to talk about the WACs, and that is the Washington Administrative Code. And what that is that's basically the sort of the instructions for people about how do you actually implement this law. And it's written in a really helpful kind of Q&A format. So it's almost like an FAQ of what do we have to do about this? And then it will answer that question.
Yeah, I was more familiar with RCWs before, and I've just been diving into the WAC, and it's very helpful and outlined, like Jake said, in like more of an FAQ or what to do kind of way. So if you're looking for a good time, I would check out the WAC when it comes to confidentiality, because a lot of this is very spelled out.
So a couple quick questions here. Are there different RCWs for non-DV programs? Yes, there are a lot of different laws related to confidentiality, and if you're in a different kind of program that's not an advocacy program, then you need to be familiar with what those rules are. Although if you're getting any kind of funding for domestic violence or sexual assault services, a lot of these same restrictions probably apply through either federal law or grant requirements. So most of this is going to be relevant to everybody who's working with victims in that sense. And then the other question here is, can you talk about instances when privilege is blown, or how to having a third party present for a conversation changes confidentiality protections? So that is specific to the privilege piece of that law. So if you're talking with a survivor, it is really important that it is a conversation just between the person that has that holds that privilege, the advocate, and the survivor themselves. If there is somebody else in that room, whether it is a friend or a family member or a counselor or law enforcement or prosecutor or whoever, then that privilege may not apply. So that is one important caveat to that rule. Thanks, folks.
Okay. So we will talk about subpoenas a bit later, and so we can take up that question when we get to that part of the webinar, if that sounds good. Okay, so in terms of pointing you in the direction of the relevant WAC around this, you can see here, this WAC spells out what information a DV program must keep confidential. And if you really get deep into this world of confidentiality and technology safety and whatnot, you'll see PII come up a lot. And so that acronym, which I won't be using that today, but just in case you are like diving into a lot of these confidentiality resources, you might see that come up a lot. So that's personally identifying information. And there are some very specific definitions out there of what that means, but basically, any information perhaps on its own or with other information that would identify somebody. And so that information, as well as your communication about them, need to be kept confidential. And what is confidential information? Again, those are reports, records, really any documentation that you have about somebody, and it does include electronic files as well.
So just to underscore for a minute this piece about personally identifying information, one place that may come up most commonly is around funders and grant requirements. If folks are asking you to report information to demonstrate what services you're providing for a grant that you're getting. So, or it could come up around other kinds of databases where we're trying to, collect and share information. So we have to really think through what's personally identifying information. It's not just names and social security numbers. If you are sharing information, for example, about people's demographics, race, ethnicity, age, medical information, anything like that, that might come up in a report that you're doing for funders, that you have to be really cautious and sensitive about what combinations of that information can be personally identifying. And in these days, especially when there are such an ability to kind of collect all of that information and put it together, there are lots of things that we might not think of as personally identifying that really are personally identifying when you put them into a database like that. And so we have to be really cautious about that to make sure we're drawing really clear lines with funders and grant managers about those restrictions. And if you have questions about specific things about that, please give us a call and we'd be happy to help walk through some specific scenarios if those come up for you.
Yeah, great. I think that's really key, Jake, is just remembering how, when paired all together, something might be very identifiable that you otherwise might have thought maybe it wasn't. Yeah.
Especially in a small community, but more and more everywhere.
So more specifically what this means that as we've been talking about, you cannot release any information about a client without that explicit permission from them. And so the authorization to release information must be written, and it must be signed by the client, and it must be time limited. So it can't just be you can talk to this person into perpetuity. There needs to be a time frame around that, and that is to offer an opportunity to revisit that relationship, revisit what's being shared with the survivor, if that still makes sense. And just to, only be, the idea is really that we're only sharing information that needs to be shared for a specific reason. And so, if you're just making a specific kind of referral and that's really only going to take a month, it might even only take 2 weeks. Like, you don't need to just do a standard, like, let's say, standard 90-day release or something for a relationship that's not going to last that long. And, so making it time limited is really important, just in terms of, limiting if you're thinking of it as like, a small door that's open, like, you're just limiting the doors that would be open to leak information out of. Okay, so we have a question: if clients unable to physically sign an ROI, can it be done another way, such as over the phone?
Yeah, so this is a question that comes up a lot.
Mhm.
um, because especially as we're doing more and more mobile advocacy and people are trying to communicate with people by phone and text and all of those things, it's a big pain in the butt to get a signed release before you do work with somebody. And so that I think is one of the biggest practical barriers, because most of the time when we have confidentiality breaches, it's not because we're trying to get around those laws. It's because we're trying to do the thing that's going to most efficiently help this person in the time that they need the help. So it's going to be really, that is one of the biggest challenges, is just the practical things about trying to get a physical signature from somebody. So the law is really, really clear that the authorization must be in writing, signed by the recipient. There's not a lot of wiggle room there. But there are some things that people have come up with that are the best practices. So one of those is to scan and send that release as an attachment. If somebody is able to, sign that or put an electronic signature on it and send it back, that's a good option. If you can do an electronic signature and you're sending that by email, if you're doing any of those things, you want to just make sure and verbally confirm with the survivor that that's what they want, that they understand it, and that they're sending you that signed release electronically. And then sort of a last ditch option would be to do a retroactive signature, which would mean that you read this to the person, get their verbal permission, note on the form, this person couldn't sign it because they are wherever, gave permission over the phone, will come and sign on what date, and then try to get that signed as soon as possible. So that is the sort of the most flexibility that we have, given how clear that law is.
Yeah, and I think the important part really is, remembering that you really do need to talk on the phone with a person about it, even if you do, let's say, have them sign an ROI on an email. Like, just responding to an email and saying, like, yes, it's okay for you to talk to that person, or a text message saying, like, yes, it's okay for you to talk to that person. That really isn't, um, obviously that's not a replacement for a written signature, but it's also unsafe in the sense that anybody could be responding from the survivor's phone or their email. So you really do need to make sure that, like, even if they are going to sign and return something, that, like, it's something that you've talked about, either on the phone, or made a plan about face to face or something like that.
And I think one of the biggest things from an organizational perspective is just to think this through and make a plan and have a protocol for it in your agency in advance. Because it's not something that is a rare instance that we can't predict, right? Like, we know this is going to come up. So what's the protocol for when that happens? If people have things that they've used that work well and are compliant with the law, like a system that you have in place at your agency, feel free to share that in the chat too. We'd love to see it.
Okay, and then just to highlight, for a minor, the child and the parent or guardian must provide that written authorization when it comes to a minor, and the abusive parent cannot authorize release of information. So we are looking for the survivor or parent of that child to provide that authorization when it comes to minors. So when it comes to making those releases, you want to make sure that you are only sharing information that was specifically authorized by the client. And I honestly have found in advocacy practice this to be a very great conversation to be able to have with folks. Sometimes they haven't, been given the opportunity to be like, oh, what do I want shared with this person? Like, oh, please only share that, I'm looking for housing and this is the makeup of my family, versus like specifically what happened to me or anything like that, and that's information that you wouldn't really need to be sharing already, but just like being able to have that conversation with the survivor and then be able to express what they feel comfortable with can be, part of that process of self-determination and like learning what it looks like to be able to set boundaries and make decisions for their own life. And, have it focused on the specific information needed for that situation. Um, it doesn't, if you're only talking about making a referral to a legal clinic, they might not need to know this, that, or the other about a person's situation. It might really just be, specific information we're sharing is like this referral form. So really think about that purpose and ground and focus in what you're sharing based on that. And you don't need to worry about the other stuff. Just be as specific as possible.
So one question from earlier is, if you're participating in a multidisciplinary team, is there a blanket ability to share information? So the answer to that is definitely no. That release does have to be specific and specific to what information you're sharing with who for a time-limited purpose. That doesn't mean that you can't do meaningful collaboration, though, with other agencies. I mean, for one thing, the other folks might be able to share information with you, even if you can't reciprocate that, and that may be useful. There also may be times when in those meetings you can share information about survivors' experience generally, about what your agency's policies are, about what might happen if someone were to come to you in a certain situation. So there's lots of ways that we can participate in those and be helpful even without releasing information that's specific to a survivor that we're working with.
Right. And that, receiving that information could be really helpful in your further conversations with the survivor about how things are going with that other agency, or about how, you can advocate for them with that agency. So I do, even if you can't share, getting information from other folks, if that's what they're wanting to share, is definitely, that could be helpful. I just have some other questions here. About the age of children and ROIs?
So there's some specific language in there about, with that bullet point about the abusive parent can't be the one to sign. Let me look that up and I will come back to you on that.
Okay. So we will follow up with that. And then we had some other questions about the age of starting to have children sign their own ROIs. So we will dig in. Jake is on the case and we will follow back up about that. Okay. So the bottom line is you cannot share information about a client unless you have that written, informed. And so informed being like they really understand what's going on, have that conversation, specific, time limited consent. And this isn't just because the law and our funders say so, but it's because it's a core part of our values when it comes to advocacy. Something else I will say is just like while I was working on this webinar, I was just like having another moment of really loving advocacy again, and just that we put so much care and thoughtfulness into something like this when, let's say, most people, you go to the doctor and like you have to sign forms for HIPAA, and it's kind of like everybody just has to sign them, and there's not like this really dynamic conversation around things. And so, I think it's actually really an asset that we're using confidentiality as a way to have conversations about what survivors feel comfortable with other folks knowing and not, and to build trust and know that we really take it seriously. Okay, we had another question. What about sharing defendant information with a system-based advocate to get help on a case without formally disclosing that you're working with the victim. Um, you know, so my thoughts on this would be that, you know, if you're sharing defendant information, um, I'm guessing this is this coming from the place that you're a community-based advocate. I guess, you know, if you're sharing information that isn't about the survivor themselves, but it's about like the person who's harmed them, that would still be sharing information that you gathered from the survivor. Um,
Oh, I see.
yeah, so you know, if that's if that's information that you gathered through your work with the victim or survivor, you know, I would say that that would still be information that is privileged, and you know, you would need an ROI to talk about that.
Yeah, and I think going back to what you were saying earlier, Heather, there are going to be circumstances where this isn't possible, but in most cases, that is a great opportunity to talk with the survivor about how you can be helpful and how that person wants you to be helpful, and what are the potential risks, what are the potential benefits, what if for you talking with this system advocate or talking with the prosecutor about whatever information or perspective you have, how is that going to help them? What are the potential risks to that? How do they feel about that? How do they want you to use that information? I think it just comes back to the fundamental principle that this information doesn't belong to us. It belongs to the survivors that we're working with. And so anything that we're doing has to be on behalf of that person with their consent and their informed consent, and with their opportunity to talk through with you, how do they actually want you to do that? Just to come back to the piece about kids for a minute, I wanted to get the specific language about that. So this comes from the Violence Against Women Act, and it applies to any programs that get federal VAWA funds. So that's any DSHS, VIPSA, STOP, grants to encourage arrest, any of that money, this would apply. And this is about the consent for minors. So it says, programs cannot share information without the consent of the person, or in the case of an unemancipated minor, the minor and the parent or guardian. So and here's the piece about the other parent. It says, consent for release may not be given by the abuser of the minor, person with disabilities, or the abuser of the other parent of the minor. So that means that if you are working with a survivor and their abusive spouse, who's the co-parent of the child, asks for that information, they cannot give consent for that information to be released, and they can't give you permission or direct you to release that information about the child to anybody else. So that comes from VAWA.
And just touching on privilege again, this is directly from the RCW on privilege. Just wanting to highlight that the survivor has the ability to voluntarily waive the privilege. So, you know, sometimes a survivor will like waive privilege because it could be something as simple as like they want their friend that came with them to sit in there, and like if you have had a conversation with them about it and they understand what that means for their confidentiality, like it is the survivor's decision to voluntarily waive the privilege. This is really going to transition us into talking about exceptions to confidentiality, but just wanting to emphasize that, you know, there is this privileged communication between you both, and only the survivor has the ability to waive that, and you should definitely be having a conversation about that.
In most cases, this is not going to be an issue. It would come up if somebody is in some kind of legal proceeding and are worried that you might be called to testify or give information. We had a question in the chat earlier about interpreters. Having an interpreter in the room wouldn't affect this privilege because, as Heather said, the assumption is that this conversation is intended to be confidential. And the reason that having somebody else in the room can pierce that privilege is that then the assumption is, well, if you're willing to say this to other people, then it's not really confidential. So having an interpreter in the room is just for the purpose of the communication between the advocate and the survivor. So that's a different story. I mean, you have to be able to make the case that this is something that the survivor intended to be confidential.
Okay, so now we're going to go into some exceptions to confidentiality and privilege. And yeah, we'll share information about the most common exceptions, which, the first two are related to imminent harm and mandatory reporting, and then the last are, direct requests for information. And we will talk about those, and then have some different resources to point you to for if and when those things happen at your program. So when it comes to imminent harm, um, we are talking about the fact that your failure to disclose the information that's the survivor shared with you is likely to result in a clear and imminent risk of serious physical injury or death of the client or other person. This is more often than not likely coming up when related to self-harm and suicidality. So I did want to highlight that if you have mental health concerns about someone, as opposed to jumping to breaking confidentiality, the next steps around that would be related to talking with the survivor about their mental health, getting them connected to a community mental health agency or a therapist, calling a crisis line together, making a safety plan. Those aren't things that we're going to go into today, but if you feel like your organization needs some more training or support around that, I know, like, as advocates, we are seeing a lot of folks that have mental health concerns, and it is a huge area of overlap, but we're not mental health professionals. So that's not really, we as advocates don't have that like thorough training around assessing those things. So, being able to do some safety planning, basic safety planning around that is important. And then being able to connect to other professionals who really do deal best in assessing a person's situation when it comes to mental health. Another exception to confidentiality, mandated reporting of child abuse or neglect. So if you go to this RCW 26.44, that's where you will get a lot of information about that. Again, wanting you to use your best judgment to determine if your duty to report really outweighs your duty to maintain confidentiality. Really wanting to ground in like the fact that you are hoping to be able to maintain confidentiality, and like, what does your duty to report really outweigh that, and being able to talk about that with your supervisors and your team, and really be able to think through that. Related to this, I did want to emphasize that it is not reportable to child welfare if a child has been exposed to domestic violence. This is not the case in every state. So if you're not from Washington State, definitely look into what the specifics are for where you're at. But in Washington State, exposure to DV in and of itself does not constitute child abuse or neglect. So that does not constitute a mandatory report. I'm just going to check in on the chat here. Yes, wanting to back to the privilege conversation we were talking about, the survivor having being the only person who could waive it. Don't assume that they have waived it. Like, privilege and confidentiality are starting points, and so them being waived or that being different is like, that's the exception, and that exception needs to be like thoroughly looked at and discussed.
And just like we'll talk about in a minute with subpoenas, something like privilege not applying, not protecting the survivor is never a conclusion that we should come to. That's going to be something that another party is arguing, right? So an opponent in court might say that privilege doesn't apply because X, Y, Z, but we're not starting there. We're starting with, we have this privilege. Let them make the case. They're going to have to argue that, and then our job is to argue that yes, it does. So the same thing will come up with with subpoenas, just because somebody makes an argument or asserts something doesn't mean that we're just going to do that. So, as with a lot of these things, it's not like it's not self-executing. It's not spelled out in black and white that if another person enters the room, now your privilege disappears. It means that that may be something that compromises it, that somebody else may be able to argue that you don't have that privilege. But it's our job to argue that we do and why we do.
Okay, and just wanted to highlight around, bringing it back to this conversation about how confidentiality can really build trust. There was a report that was put out by the National LGBTQ Institute on IPV called There's No One I Can Trust. It's a really great report about mandatory reporting and people's experiences with mandatory reporting on a national level. And so just wanting to know that 3 out of 10 people didn't receive any preparation before a mandatory report was made. And we're going to talk about this further when we're talking about different policies and procedures, but really just knowing that there should never be a breach of confidentiality happening, or confidentiality being, well, not a breach, but confidentiality shouldn't be broken to make a mandatory report without a discussion being had with the survivor first, informing them of what's going to happen so that they're able to make a safety plan with you accordingly, think about what is going to happen, how it's going to impact them, their children, other folks involved, and just, knowing how those reports more often than not have no impact or make a situation worse. And that just makes it all the more important that you're able to talk with the survivor first before making that report. And that will also just help when it comes to building trust and them knowing that you're not going to do anything without discussing with them first. Some other resources around this that I just wanted to point out quickly, the Social Workers Practice Guide, if you're not familiar with it, and some other Know Your Rights resources from WSCDF when it comes to CPS and DCYF. And as I've been mentioning, some best practices when making a mandatory report, make sure that you are sharing your requirement to report with the survivors that you're working with. That's something that you can talk about at your first meeting, but something that you can bring up. But, if it seems like something is going in the direction of a mandatory report, and then just being able to talk to them about what that looks like and maximize their role in the process. And then just knowing that records could be requested as part of that mandatory report, which we're going to get into more specifically the extent of that, which is actually pretty minimal. Even so, keep very minimal records and separate records about an adult and a child. We're going to highlight this later, but by keeping them separate, that way, if information about a child is requested, you're not sharing information about the parent or vice versa. Okay, I found this resource to be very helpful, even though it is from 2007, but it is still very relevant and really well done by the Battered Women's Justice Project, which I'm sure a lot of folks are familiar with. But I just wanted to let you know that they do a really great breakdown of some of these other exceptions to confidentiality that we're about to go into. A lot of the court order related stuff is detailed very well in this guide. So I would take a look at that if this is something that you're encountering. Okay, so here is the RCW 70-123075, that a release of information is otherwise required by law, court order, or following in-camera review. So we're going to talk a little bit about the court orders related that you could receive for request of records or a subpoena for an advocate or something like that. Did want to remind you that it is unlikely that law enforcement will be able to obtain a warrant because of the federal level VAWA protections. But, in the event that it happens, there's a lot of information out there about the objections that can be made, and the arguments that can be made to protect the survivor and their information. Okay, so when it comes to search warrants, and with all of these things, really just wanting to encourage folks to slow down, take a minute, review what's going on. It can seem really urgent or pressing. It might not even just seem that way. The person who is bringing you that warrant or request might have a lot of urgency themselves. So, being able to like ground and take a minute to assess what is really going on and what you really need to do or not do is going to be key for all of this. So for a search warrant, you would want to be making sure that it is a written order and that it is signed by a judge. That would be something that would authorize law enforcement to search a specific location or a person or physical items related to a legal proceeding. Making sure that that would be something that is signed by a judge. Again, these are things that are they're not very likely to happen because of the different protections. A judge would need to have reviewed the situation and decided that, it was appropriate to, be an exception to confidentiality, essentially. And like I said, we're not providing a ton of information on these things, just really wanting to highlight, just because someone shows up with something doesn't necessarily mean that it's going to meet all of these requirements.
I think that's one of the most important takeaways here is that these situations, somebody's coming up with a search warrant is pretty rare, and that there's a lot of other situations that are not that. So a law enforcement officer coming to the door and just asking to talk to somebody, asking if somebody's there, asking you for information, asking if they can come in. None of those things are a warrant, and you don't have to share information. In fact, you cannot share information in those situations. If it's a warrant, it's going to have a judge's signature on it, and it will be specific about what specifically can be searched and what they're looking for.
For arrest warrants, I did want to emphasize that an order, an arrest warrant that a law enforcement officer has is not sufficient for them to gain access to confidential shelter. That includes warrants from ICE or the Department of Homeland Security. That is something that there are federal protections around for domestic violence shelters. Again, if you have more specific questions about these things, feel free to reach out to me and I can send resources your way that are more tailored to any of these concerns. When it comes to subpoenas, one of the big questions that we get, is a subpoena a court order? The answer is sometimes. It could be a court order that is signed by a judge, or it could just be a subpoena that, let's say, someone's lawyer is sending out. So that is something that you definitely need to take the time to evaluate. And when that would be coming from a lawyer that's not already signed by a judge would not, that wouldn't be already fall under the category of being a court order. Take a look at what type it is. There can be subpoenas for records, and there can be a subpoena that would be for testimony. So that would most likely be a testimony from an advocate. Take a look at what type of proceeding it involves, and your organization should definitely be obtaining legal counsel to make objections. More often than not, domestic violence organizations are, we're making objections to these subpoenas. It's not just something that we go ahead and do.
Just to know, under state law, the conditions for actually having domestic violence records admitted into court is very restrictive. So you not only need to have a court order, but the judge actually has to review that information in private before and make a determination about whether the value of that information in that particular court proceeding outweighs the confidentiality protections and the safety protections for survivors. So that's not something that's going to happen immediately. There's like several layers of scrutiny before we get to that point.
And if this is something that you have more questions about because you're in a position in the agency to be the holder of this information, or it's something that's come up before, we do have a webinar that is still very relevant and helpful when it comes to this, and does not offer legal advice, but gives some of the basic rundown of subpoenas for records and testimony and some guidelines for advocates and managers to have. I highly recommend taking a look at this webinar, which is on our website, and that can be helpful if this is something that you want to dive further into. I believe earlier we had a question about whether, what about an advocate, when an advocate is subpoenaed and the client wants them to testify. I mean, I think that would be a larger question about even if, in the event that an advocate was required to testify, like what they could share, and all, like just the limitations of that, and how even if a survivor feels good about the things that they've shared with you, just like how that can be used in court, and some talk about the limitations and biases that exist in the legal system, and how that may or may not work out for you. I can for the survivor, and I would give this webinar a listen, and then we could talk further if that's something that you want to reach out about, really what the considerations would be, because I think that sometimes the the choice is in the survivor's hands, but I think sometimes it might seem like, well, I have nothing to hide, or something like that. And while that might be true, there are just ways that information that the survivor might feel is neutral or positive could be used against them, as it often is. Okay, so in the event that you are required and one of these exceptions is applicable, just wanting you to remember minimum disclosure to meet the requirements. If you are required to report a situation of child abuse or neglect, that's all you need to talk about. That in particular, we're going to break down a little bit further, but minimum requirements. Just because you had to say this one thing to meet a law, it doesn't mean that you have to say all the things. Make sure that you're talking with the survivor about it, and doing some safety planning. And just remember that you are an advocate, and be an advocate in that. Handle it in that same way that you would handle anything else. And do the safety planning, be really transparent about processes around that, think about pros and cons, all of that. We had a question about filling out an ROI. Can the client use acronyms, or do we need to write out the full name of the agency? I would think best practice would be to write out the full name of the agency. Even, we live in acronym world, but some acronyms are reused, things like that. But it might not be, I don't think that that's a huge issue if you do use acronyms. Everyone making a legal referral to NERP, we know what NERP is and what that means. And if someone else calls up and is like, I am also NERP, you might want to question that. So, I don't think that's a huge issue, but if you can write it all out, that would be ideal. Just some more reminders. We hold a lot of power in having the information that we do about survivors, and so just wanting to ground in that, take that very seriously. That information does not belong to you. It has been shared with you, and that is it's a really intimate, powerful thing. But we want to make sure that we know that that is power that we are not wielding, and that we are bringing it back to the survivor for them to decide what to do with that information. And being stewards of that information is that's a very serious role, and so we take it seriously.
I think the way that we talk about that with survivors and in the community, every time that you share information or don't share information and communicate with people why that is, we're sending a message about what survivors can expect from our programs. And we're sending that message to our community partners, to other systems, to survivors, to their families. And it's so important to be really putting that out consistently.
Okay, and we got a question about something that I was going to talk about. Do we still have those little "it's not ours to tell" cards? Yes, we do, and we have a lot of them. So we would be happy to mail you some of these cards to your program. I'll pop in on video at the end to show what that card looks like, just in case folks would like to know.
I'm pretty sure it's on our website, isn't it? So you could download it.
I would be surprised if it wasn't.
I'll find out. If not, we can put it there.
Yeah, but we do have a lot of those on hand, and that's just like a little card that has the key RCWs around confidentiality and privilege, and then has some steps for advocates of what to do and say in a situation. It's like about the size of a business card. It's like one of those palm card things that advocates can have on hand if they, I don't know, let's say they're at court with someone and a lawyer comes up to them and they're like, because it's overwhelming, and like a lawyer came up to me and they want information. This is like, the idea would be that an advocate could have it with them and like take a moment to like breathe, read it, make sure that they remember all those good things about confidentiality that they likely already know. Okay. Again, let survivors lead. It's not about our control or knowing what's better. If a survivor is okay with you discussing something with someone and you've talked it through and you've done the release, you've done all that, it is their decision. But we are still taking that very seriously and keeping it specific and limited and all that good stuff. That is our number one priority at the end of the day. Survivor is the decider. That's a good thing to remember always, not just for confidentiality, but it's good to bring it back into the confidentiality conversation. I've seen this happen in terms of like advocates maybe getting stressed about confidentiality when, let's say you go to court with someone and they decide to bring a friend and you walk up to them and they're like, the survivor is like, this is my advocate to their friend, and then the advocate feeling like, what do I say? Like, I'm not supposed to say that I'm their advocate or whatever. And, that was a survivor's decision to introduce you to someone in their life. And so, that doesn't mean that you just start divulging everything that the survivor ever told you, but like just knowing that like even just identifying that they're working with you or something like that is the survivor's decision, and like they can decide what they're telling their friend, and like that doesn't have to impact what you're sharing necessarily. Okay, so getting into some internal organizational strategies that you can have when it comes to confidentiality. We're going to touch on all of these here and would be happy to hear from folks around anything else that we want information on. So thinking about how the survivor's autonomy comes first, how does your organizational culture reinforce this value? Thinking through all of these different pieces. And that's not just when it comes to confidentiality, but that's just in terms of survivor autonomy in general. How is that embedded in your organization in all of these different ways? That's a good reflection to have, just making sure, that there's not unnecessary barriers or mandates or things being put on survivors, and that there's a lot of space for choice, conversation, consent, and all of that when receiving services and just in different practices.
The day-to-day conversations piece of this is part of it. It's just how do we talk about this with each other in our regular work? There was a question earlier about what about sharing information within an organization? And I think that there's a difference between the legal piece of that question and the organizational culture / ethical part of that question. That legally that person's confidentiality is with your organization and the individuals within it. So if you're talking with somebody else in your organization about how to work with this person that you're both working with, that's not a problem from a legal point of view. From the organizational culture and just ethical, and how do we set ourselves out as a role model and communicate to survivors what we are about and what they can expect from us, there's, I think, other things to think about, like just how are we having those conversations? Is that happening in a way that is really intentional and has a purpose and is clear, or is that happening in a way that's a little bit more loose and can sometimes drift toward the gossip realm of the world? That those things are things that, how we individually think and talk with each other about that has a big influence on not just what the whole organization is doing, but also how survivors are experiencing that. If somebody believes that when they come to your organization for help, their business is going to be getting around to everybody that works there and everybody that volunteers there, especially in a small community, that's a huge barrier to overcome for somebody reaching out for help. Versus if people see you setting an example of being very cautious and intentional and respectful about how we treat people's information, that just inspires a confidence that is going to make people safer because they feel like they can reach out for help.
Yes, absolutely. And, I have worked at a variety of different social service agencies, and I've seen a pretty wide spectrum of what this looks like. And I just think it's good to remember that, it really does impact more than, it's not just what you shared with your coworker. It like really has an impact on how we think about survivors and how we work with them. And, it's that judgment piece that's coming up. And so I think if that's something that advocates are struggling with, it could also have to do with burnout. It could have to do with a number of things. And I think there's a lot of ways that can be addressed. And I think just in general, it will improve organizational culture for the better, the less that happens. And then, we are getting some extra information here that as per the WAC, the information sharing among staff is specifically limited to within the DV programs. So not, if you're an agency that has a DV program and then you also have a counseling program or a childcare program or something else,
housing or anything else.
Yeah,
that's more like your multidisciplinary team scenario where you're working with other organizations. That information sharing is still very limited to domestic violence advocates working with other advocates in that DV program. That is all spelled out in the WAC. And again, if there are specific instances that are coming up that you want to ask us about, you should email Heather about that.
Yeah. Okay, minimal documentation. So here's an example of what very minimal documentation could look like. Could look like a date and perhaps the format of how you met with somebody. I've seen information I've seen this done a couple different ways. I've seen, there being service codes at some organizations, or, just a different column to check what happened. So, very minimal documentation that does not include direct quotes from the client, any assessments of their emotional state, or if a survivor, when it comes to mental health, the King County Gender-Based Violence Coalition has a really great tool around mental health and the legal system, and that training really, for me, solidified why, you don't need to write down any of a survivor's diagnoses that you're working with, even if they're sharing that with you, but that's not something that you need to document because, again, that is likely something that could be used against them in the event that your records are ever able to be accessed by someone. And, we're just preparing for that and knowing that just on any given day, if you had to hand over your records, just knowing that the least amount of information possible is what is going to be protecting the survivor. So nothing about their feelings or other things like that. Obviously, that's important information for you to have to be working with them, but that's just something that you can know and have and be talking through with them, but you don't have to have in their file or on record.
Once again, that's not just good advice. It's clearly spelled out in the WAC that those things should not be in your record keeping.
And I do also want to highlight, I don't have a ton of information about this, but it's my understanding that, for instance, therapists do need to, especially under some programs like Medicaid programs and things like that, they actually do need to write down direct quotes from the client. So this is the opposite of that. So if there, if you are also a therapist in another setting, or there are therapists at your organization, things like that, being able to have a larger conversation about this, just to make sure that you're meeting confidentiality for the various roles that you're in. I just did want to highlight that that might be something to dig into if that's an applicable situation for you.
Yeah, and it's something that can be a challenge in multi-service agencies or bigger agencies. And so it is important to be asserting that your domestic violence program has its own restrictions that may not be true for everybody in that agency.
Okay, so mentioned this earlier, but separate children and parents records, again, so that if one record is needing to be shared, the other does not need to be shared. Some tips for good release forms. Mentioned some of this already, but being as specific as possible, having them time limited, including what to say and what not to say. So specifically what you are going to share with that person that the release is for. If you say something like very vague, like information about services received, that is very open. And so we're wanting to be more specific with that. And then properly disposing of releases after the fact is very important as well. Depending on the work that you're doing with someone, you might have quite a few releases that are around specific issues that you're working on. So just making sure to properly dispose of those. Going back to the note about the therapy records, those, should also be kept separately since their professional obligations are different. Yeah, thanks for that, Meta. Okay, so now thinking about how, we've talked a lot about how you should have these conversations with survivors, or we know you are as advocates. So I would just love to hear from folks in the chat box, what are some ways that you talk about this with survivors? Maybe some key, maybe you have some key phrases just off the top of your head about how you usually talk to it, or like what's your little, what's your elevator speech about confidentiality. That would be, that would be really great to hear. And I kind of want to crowdsource our best tips. So yeah, if you could just type in the chat box, even something short of, or maybe there's a way that you talk about it with people that you feel like really resonates. Because it might not be something that they're familiar with, being able to, have this protection and use it. Anything for folks? Yeah, everything is between you and I, unless this document is signed, giving me permission. Everything we talk about stays here. If you want me to talk to others, you have to fill out these forms, conversations about pros, cons. So some other agencies might have it spelled out on a consent form. I've heard of places reading it to people, things like that. So making sure that people know that this is going to be an ongoing conversation. And then yeah, I think it's really important to highlight not just the release piece, but the reasons that you might be the exceptions to that confidentiality. Okay, so just some key points that I wanted to emphasize, things that you can say. You can emphasize how seriously confidentiality is taken, um, having those clear and limited exceptions that you're sharing with people, really emphasizing that the information belongs to the survivor and you need their permission to share it. You can give people examples. I would often do that. Say if so and so calls up here and says, is Heather receiving advocacy? I need to find her. I don't, who knows what, or even something more vague and less direct than that, that you're neither going, you're not going to confirm or deny that, and that someone won't be able to just inquire and know that they're receiving services there.
It's also important to give some of those examples, and especially if there are situations where the survivor actually wants you to share information, letting them know in advance what they would need to do for that to be able to happen. So there was a question earlier about if somebody says to you, if I'm not back in 48 hours, you should file a missing person report or tell somebody else that. If somebody wants you to share information, this comes up in, we have a model form that lets survivors give you permission to release information in the event that that person dies or is killed. Okay, so that's one situation. If somebody is missing, if they tell you, if I'm not back here, I want you to call my mother, call the police, whatever it is, getting that person's written permission and talking with them about what that might mean in advance. It's not just that people know what you can't share, but also that they know that they're going to have to do something proactive if they want you to be able to share information. And I've seen a few folks referring to having this information written out and having written policies and rights for survivors that they can read and refer to. That is excellent, and we should definitely have that. And I think it's super important to talk through this. All of this stuff, we could have just given you the one pager that Heather did, but we've spent 2 hours talking about this, and we won't even cover all the potential situations. So just having a chance to actually give those examples and talk it through with somebody in a real life way is real important. Even though I know that's demanding and challenging with the time that we've got.
And, those are also conversations that need to be had about protecting others' confidentiality in situations where survivors are going to be interfacing with each other, and what that means and how important that is. Also talking about what will happen if you run into each other out in the world, letting survivors know that you're not going to be acknowledging them first. And if they want to interact with you, they're going to need to initiate that interaction, that you won't be, that you're not trying to be rude or ignore them or anything like that. You're just trying to respect their confidentiality and their ability to move through the world. And even if they love you and think you're doing great work together, maybe they don't feel like tapping into all those feelings that come up when around this like traumatic issue that you're working on together. So being able to talk about that first can avoid any hurt feelings. And in small communities, I'm sure a lot of folks on the call are like very seasoned in what this looks like. I was once in a situation where client who I was working with, like their kid actually like saw me at a thrift store and like crawled under the dressing room door that I was in. But like, I didn't I didn't do anything special or different. I mean, I reacted how you would if that would happen. But I didn't acknowledge that I knew that person or anything like that. And like they didn't acknowledge it either because they were very embarrassed. And so like just knowing like, you're gonna see people, things are gonna happen, and like you don't have to feel like confidentiality is like thrown out the window because that happens.
So there's a lot more questions, and we're getting a lot on record keeping. There is a lot more to say on that we won't have time to get to right now, especially when it comes to electronic record keeping, but we can send you a couple of other good resources about that.
Yeah, and I'm I noticed this at the beginning, and I already have this bookmarked, like needing to take on very specifically like email and text message communication. Um, thank you for giving us that feedback, and that's something that folks are needing. So I will definitely be on the case when it comes to putting together some resources and getting some clear information about that back to folks. Again, so we mentioned before, like some of the challenges with this, it's all sounds great when we're just talking about it in theory, but what are challenges to maintaining confidentiality in the moment? Others, they might not be grounded and like very into the fact that you are going to be maintaining confidentiality. People might be in a hurry to get information. So, just knowing that, and the fact that you're still going to need to maintain confidentiality, have your process around it, and slow down, do what you need to do to make sure that you are maintaining confidentiality, only sharing what's appropriate and with survivors' permission. Those are all just important things to keep in mind. The challenge, like Jake mentioned earlier, like we know that people, more often than not, confidentiality is not breached because of like ill intent. It's because, of pressure or trying to get things done for someone and like really not wanting to have to go through this whole process. And that's just, that's just part of the way that we work. Those are things that we are both held to legally and by funders. And like we've already discussed, like it has all these other impacts around trust and people accessing domestic violence services. Something else that you can have in your back pocket that will help when you're being challenged or people are asking about, what DV service agencies maybe they're not familiar with, and you're explaining your practices, know the laws. That can be a really helpful way to point people in the direction of what we're basing our practices on. And just knowing that, I think, can be really good guidance for you to know, ground yourself, the law, what you're doing. And so you can maintain confidentiality in the face of those challenges. Oftentimes, I think we can feel like a broken record when it comes to confidentiality. You might have to say the same thing a couple times to someone, and eventually, I think a lot of people who we collaborate with on a regular basis, they learn this, they get to know, and then, that will help the relationships in the long run. But in the interim, when you're facing those challenges, really can just be a broken record, and repeat the same thing. And, people will start to get the message. And if it's a larger like organizational relationship that you're having, which we'll talk about in the external confidentiality strategies, like people will get to know what it looks like to interact with your agency about folks. Okay, you do want to get back to people in a reasonable time frame, even if you're saying that you can't share anything with them. You might be wanting to follow up. Let's say, like for instance, the survivor went and applied for housing, and you're going to be providing some sort of financial assistance or other advocacy, and the housing provider reaches out, but you're not allowed to respond because you don't have an ROI. And then you talk with the survivor, and then you do get an ROI. Like, just make sure that you're following up on these things in a reasonable time frame. Just because you can't provide information doesn't mean that you are like blowing people off. It just means that you aren't sharing anything that you can't, and you are still like evaluating that situation and dealing with it. Okay, so just wanting to do a brief scenario here. Scenario is survivor Julia and CPS. So in this scenario, a CPS worker called. They want to know if Julia's in shelter because they required her to come to shelter, and they want to confirm she's there. And they haven't heard from her. That she's gone for the day. And no one on staff knew CPS was involved. That's not something Julia shared. And so there is no release for CPS. Question for you all in the chat. What should the advocate say? Can't confirm or deny. They can take a message. Right. I think it is good to let them know that, if there is a situation where a survivor wants to work with CPS, that, they have them sign releases and like have the, you can say some other things that are more about your organizational practices if you're feeling like that will like smooth out the relationship with that person or whatnot. But, more than anything, that you don't have any information that you can share. It's really important.
Right. So saying something like, you're welcome to leave a message, or this says if any of the residents we're working with are CPS involved, we offer to have them sign a release or encourage them to contact CPS on their own. I think what that comes back to is and what we can keep on communicating is that the relationship is the advocate's relationship is between the advocate and the survivor. And then what you can do is support that person to make decisions about how they're going to communicate that or navigate the CPS. But we don't have an obligation in that situation to share information directly with the person that's asking for it.
Okay.
And, there are those times when, maybe this is what we're about to get to. There are those times when you can worry that it's going to make the situation worse for the survivor if you don't answer that question right away,
right.
Or if you don't come across as being helpful or cooperative. So that's something to be thinking about, and how are we going to communicate with this person in a way that doesn't sever that relationship, that makes it clear that, what our role is and why that's our role, but also holds the line on, no, I'm sorry, I can't share that information with you, or I don't have any information to share with you.
Yeah, so we're going to discuss some different fears that come up, or things that people might say to advocates that really, make you feel kind of terrible. And what are the ways that you can ground yourself in ways that you can respond to those things in the face of it? Okay, so has anyone heard, you can raise your hands in this instance, that would be a good way to use the feature. Has anyone heard, I thought we were working together? All right, yeah, so we got some folks that are raising their hands. Some ways that you can answer that. Yes, we are working together, but we have distinct roles, or, my role requires me to protect the confidentiality of survivors I work with and not share information without a formal release. And, or I don't have a release for the information you're requesting at the moment. You can still emphasize with them that you are working together. It's just you have different limitations to your role and what that can look like. You're obstructing justice. In that case, you can ask someone what law they're referring to. They could just be saying that in frustration. But, that would be helpful to know. When I did some rape crisis advocacy in Florida, I was in a situation where a detective said some not quite that I was obstructing justice, but, he said that I mustn't care about justice and that we weren't working together and all, this slew of things, because I wasn't going to share information about whether or not I was working with the survivor or being in touch with them. So, people will say a lot of things that, if they're frustrated, and just being able to ground and maintain what's going on for you. And a huge part of that, and what made me successful in that situation, was having my supervisor and other folks that I could lean on who were backing me up and letting me know that, I was doing the right thing, and that no, we weren't going to give information to this person. And like, if someone is really escalating, also being able to like tap into your supervisor to potentially speak with them as well, if they're trying to push you around and things like that. Having that support on your team can really take this from being like scary to just like something we're handling as a team. We know how to do this. We know what confidentiality means for us, so we can handle it.
It's helpful to remember too that the person on the other end of this interaction, they've got their job to do, they've got their goals, they've got their role to play. They're not speaking as the neutral arbiter of what is right and what you have to do. They're speaking from their perspective about they want this information, their job is to get this information. Your job isn't to help them do their job. Your job is to make sure that we're doing everything we're doing on behalf of survivors. Doesn't mean we're not working together, but there's other people's agenda is not necessarily our agenda.
Right. So some other things that you might hear, this kid could end up dead, or, even this survivor could end up dead. Obviously that's something that none of us want to see, something none of us want to hear. So, just being able to stay grounded and not get defensive in a moment like that is really important, and being able to let them know that like you are concerned about safety. um, this is just your specific role and what you can and can't share, and then being able to rely on directors, supervisors, other people on your team to support you if you feel like the person is just saying some things that are getting you ungrounded, and you feel like someone with some more authority might be helpful to get involved. Okay, just gonna gloss over this one here pretty quickly, but I did want to highlight another part of this scenario. Let's say the DCYF worker calls up and wants to request records on Julia and her kids to confirm her progress and find out if she's going back or not. So going back to a person that harmed her. She claims your program must turn over, the DCYF worker, claims your program must turn over records because advocates are mandated reporters. So just wanted to, all right, so these are some thoughts that are going through your head. Oh, we are mandated reporters. Is she right? Oh no, oh, she's really angry. And I don't like it when people are angry. I want to make her not angry, all those thoughts that are going through your head in that moment. Really wanted to break it down as to what you actually need to share.
Just like earlier when we talked about just because you get a subpoena or somebody requests information, that doesn't mean that it doesn't mean it's a warrant. It doesn't mean it's something that you have to turn over information. It's helpful too to know what are the specific circumstances when we are required to share information with CPS, because it is not anytime somebody asks for that information.
Right. So they may access records during the investigation of reports of alleged child abuse and neglect. And so that is a very specific point in the process. After that investigation, the social worker would have to go through the court like anyone else to get access to records. So just wanting to be really clear about that there's not like an open door to CPS because you made a mandatory report. Yes, you are a mandated reporter. You might have reported a very specific incident that was shared with you that did meet that threshold, but that does not mean that you have to share with CPS in an ongoing way what's going on. And specifically in this instance, she said, this was related to her progress, and.
Well, for example, you might ask if you get a request like this, are you investigating an allegation of child abuse, or are you following up on a service plan? Those are two different things. I mean, if you're investigating an allegation of child abuse or neglect, then this law applies to us. if you're following up on somebody's case plan or service plan or want to know if they're complying with everything that CPS has asked them to do, that does not fall under this law, and that person needs to go to get a court order just like anybody else if they want to get that information from you. And the better way to do that would be to talk with the survivor about what information can you share or can you give her that so that she can share that is going to be helpful to her.
Right. You know, the survivor might want you to share specific information with PCYF or CPS. And so, you know, if their progress is relevant to what they have going on. So that, you know, that's a conversation you can have with the survivor, specify what they want to share so that you can do great advocacy with them. And yes, I will send out a copy of the slides with the copy of the handout that I wasn't able to share via Zoom.
Can we go back to that for just a second?
Mm-hmm.
So a couple of the things on this slide that are important are about that it applies to relevant records. So that's not spelled out. So that means that we have to use our judgment and discretion about what that means. And that it applies to written records, not conversations that you've had. And it applies to records of the child, not the adult survivor. So that really is going to limit what you can say about that or what you can share about the survivor. And it should only be directly related to the child, which is another reason to have those kids and parents records kept separately and have advocacy records separate from other things like therapy records.
Yes.
Thank you.
Yeah, absolutely. Keeping those adult and child records separate, so important because it really will come into play in situations like this. Okay, so some external strategies just in terms of your agency's role in the community and how you interact with other folks around confidentiality when it comes to boards, other things like that. So clarifying your agency's role in the community is really important to do upfront, especially when you're doing collaborative work or community engagement. You know, I have worked in different situations where maybe I'm doing like outreach at an event that's like drop-in night in like an LGBTQ youth space or something like that. Like being able to have a conversation and meeting with that agency upfront about, you know, what confidentiality means, how you're going to offer confidential services, perhaps in their space, if you are in their space, you know, what that looks like, and just talk through it all so that there's not a misunderstanding, so that people are understanding, you know, what you're offering and how you can make that happen. And getting a lot of that figured out beforehand can really do a lot to avoid some of the challenges and misunderstandings that we talked about earlier. Consistently using those releases is also just going to become really important to your work with community partners because they're just going to get used to it. You know, consistency is great. It sends a message. They know this is the way things work with your program. We're going to need a release. There's not a way around it, and that's okay. And so, yeah, consistency, really important. Roles for executive directors and boards. You know, as I've been mentioning about backing up advocates, whether you're a supervisor or an executive director, really being there to back up advocates who are like on the front lines of upholding confidentiality, having them know that like you have their back if anything gets challenging, gets escalated, that you're there to, you know, provide the same consistent message that they are providing on the front lines. You can, if there's some larger organizational issues around confidentiality with some other partners in the community, being able to have those conversations, you know, maybe ED to ED or with between supervisors, just being able to run interference for that for advocates, because that'll really help that day-to-day work to address it on that higher level. again, just having each other's back, making advocates feel supported. That's really important overall when it comes to doing really stressful work. But letting advocates know that like they did exactly what was asked of them, and like being able to back them up when someone's like, well, I tried to call over there and get information, and this advocate told me she didn't have any information, and I knew that wasn't true. I don't know why she was lying to me, or I don't know why she answered me like that. Like being able to back up your staff around that, and just continue to maintain that clear message of confidentiality. um, Again, as I've been talking about, like having those conversations with community partners, here are some things that you can say. Addressing it head on, being able to bring up the fact that it seems like there's been some frustration with the confidentiality policy. Like, let's talk about it. Let's clear the air. Let's be very clear about what our policies are, why we're doing and doing the things we're doing, acting the way we are. This is why advocates are, not freely sharing X, Y, or Z information, and just letting them know that it's not personal. This is a policy and approach that we have to center self-determination. Okay, so now we have gotten to this piece on the federal updates when it comes to data breaches. So this is something that came out last year, and the federal grants have been requiring new confidentiality policy to be on deck for organizations, and that is around reporting disclosures of survivors' personally identifiable information when receiving services funded by federal dollars. And so now grant recipients are required to report actual or imminent breaches of confidentiality. These breaches of confidentiality are not just limited to, like, let's say an advocate breaching confidentiality and mistakenly sharing information with someone, but also just data breaches when it comes to technology and things like that. I did create a news post on the website, and we have some resources around that. So if you are someone who is in the position to be making this policy for your organization, I highly recommend that you take a look at that, because it's not just our information from Wiskative out there, but the sample policies and information that have been written up from NNEDV and some other organizations have been really helpful around this. So the requirements for that data breach policy to be compliant are that you report actual or imminent data breach to the OCVA grant manager within 24 hours. You also need to notify survivors and person whose data was breached, and address the cause of the breach. So, that is letting people know that their information was compromised, and having a policy and procedure in place to do that, notifying the grant manager, or, in the case, thanks, thanks, Meta, or in the case of a DSHS contract, your DSHS contractors as well. So OCVA is not the only grant manager that would be relevant. But
Our DSHS contract managers are weighing in. Thank you.
Yeah. And if you need help creating that policy or procedure, feel free to reach out to me. Like I said, we have some sample policies and can talk through that with you. The actual versus imminent, that could have something to do with, if there was something compromising that happened technology-wise, or just anything that could happen that, like, maybe confidentiality was breached, not like directly, but was made vulnerable. You are needing to report that. Like I mentioned, this is a good place to check out if you want more information on that, or if you're in the position to be creating this for your organization. So you can take a look at some sample data breach policies, more information about um, what constitutes a data breach, who you need to notify, which is, the funder and survivor, or other people affected. Yeah, this is a good place to start. And if you have any other questions or more specific questions, definitely send them my way, because I have been doing a deep dive on this in particular. And just getting back to some of what we've talked about earlier when it comes to confidentiality breaches, what causes them, feeling like we want to be helpful to survivors, wanting to cooperate with other people. Maybe there's a sense of urgency, like really wanting to make something happen, or maybe there's just a general lack of clarity around your role. Maybe you're like the only advocate at your agency, or the only full-time advocate, and so you don't have like a team of people that are out there like sending this message to your community. You might be the one or two folks that are doing that, and that can be really hard. So just making sure that you have these supports around you to maintain confidentiality, taking time to pause. These are good tips for advocacy in general. I think when I did my survivor-centered legal advocacy webinar before, I like put so much emphasis on like grounding and being able to like talk through things with people, not bring in like personal biases or something that'll, if you're in a crisis state, like you're not going to make your best decisions, you're not going to do your best work. So
When somebody asked about the it's not ours to tell wallet cards, the number one on that list of what to do and say is take a deep breath and think. I think that's always good advice, and we just make better decisions that way, especially in situations where the stakes are high, it is fraught, or it feels very fraught, and we might be getting pressure from outside people. Always a good place to start.
right, and if you have a question about something, like take that time to figure it out. Don't like, cross your fingers and do it. Which, I think with advocates that are just like have really high caseloads, doing the best they can, potentially out in the community on their own, like it makes sense why the inertia could be going in the opposite direction. But just like being able to pause and have clarity around that is the most important thing. So we're butting up against time here. I did want to highlight some other resources. NNEDB has this whole confidentiality toolkit on their tech safety website. That's really great. That's one place that I would send you if you're wanting some more information on this.
Even though it says tech safety, it's actually a whole lot more comprehensive than that. So worth checking out, even if your questions aren't tech specific.
Yeah. The tech safety and confidentiality, like, there's some overlaps in terms of like the content, but I just feel like a lot of times you find the information in a similar place. So yeah, like Jake said, it's not just tech specific, but this is.
Yeah, that toolkit covers a lot of confidentiality things, tech and otherwise.
Another great place, which I believe Jake put a link to this in the chat, I would go to the resource library on the Wiskative website. So you can search in the toolbar, but I think it would be even more helpful to go to the resource library and then go to the option here of confidentiality, and that'll pull up all of the tools or webinar recordings, things like that on our website that have been tagged as confidentiality, or do both. You'll find a lot of great stuff in there, and if you have any questions about any of those resources, send them my way. Another helpful tool that I found if you really wanted to get into some legal documents about some of the federal protections, I found this document to be really helpful. from American University, Washington College of Law. They talked a little bit more about how to respond to Department of Homeland Security or federal agents, as well as responding to those different exceptions to confidentiality like subpoenas, search warrants, arrest warrants, things like that. And now that we're at the end here, just wanted to thank you all for being here with us. And if you have any questions at all, even if I'm not the expert on it, I will find someone who is, get you the resources that you need. Okay. All right. Thanks, everybody.
Thanks, everyone. Keep on doing what you do and keep in touch.